Good afternoon, everybody. Bienvenue to Le Monde. My name is Kevin Bosch. I am the chair of the Pearson Centre, and welcome to our ongoing podcast and webinar series. We are very fortunate to have a very interesting discussion today on the topic of rethinking justice for survivors of sexual violence. Before we begin, I'd like to acknowledge that I'm coming to you from the traditional territory of the Anishinaabe Algonquin people, with whom we continue our journey for reconciliation. I'd also like to acknowledge our sustaining sponsors for the Pearson Centre who support us all year long. AMAPCO, Ontario's professional employees, CBTU, Canada's Building Trades Union, the NWMO, the Nuclear Waste Management Organization, TikTok Canada, the Cannabis Council of Canada, Bruce Power, Sandstone Group, Fasken, and our media partner is National Newswatch, North Star Spark Advocacy. So with no further ado, I'd like to turn it over to our wonderful chair of the our wonderful president and CEO of the Pearson Centre, Pam Damoff. Over to you, Pam.
Thanks a lot, Kevin. And welcome, everybody. Today we're joined by Benjamin Roebuck, who is the federal ombudsperson for victims of crime. And he has recently released in November a report called Rethinking Justice for Survivors of Sexual Violence, a Systemic Investigation. We're also really fortunate to have with us Tanya Couch and Alexa Barkley, who are the founders of Survivor Safety Matters, and Silvia Samsa from SAVIS of Halton. SAVIS is the Sexual Assault and Violence Intervention Service. So thank you all for being here today. During my time as MP, I was really fortunate to meet all of you and work with all of you, and Ben, certainly to meet with you while you were in the midst of preparing this report, which I was able to go to the event that you had back in November with the panel and hear some of the conversation around the report. And before I even ask you about it, I just want to say thank you to you and your incredible team for just an outstanding report. I can't say enough good things about the research that you've done, the number of people to whom you've spoken. It really is something that's so important. And I'm happy to be here on behalf of the Pearson Centre to really shine a light on the good work that you've done. So maybe you could kick it off for us, Ben, and just tell us a little bit about the report.
Thanks so much, Pam. It's very nice to be here and with this lovely group of people too. Our office, the Office of the Federal Ombudsperson for Victims of Crime, conducted an 18-month systemic investigation looking at how survivors of sexual violence are being treated in the criminal justice system. We all know, I think, that the system causes pain and suffering to survivors. And one of the things that we were hearing, which is deeply concerning and part of the motivation for the report, was that when survivors are in contact with the criminal justice system, that the system itself sometimes is more painful and more problematic than having experienced sexual violence. And I think we can take accountability and require accountability from government for the system that we're responsible for to bring justice to survivors. So we spoke with nearly 3,000 people across Canada. We looked at research. We had a survey with survivors, a survey with stakeholders. We interviewed more than 100 survivors and really tried to center their voices. This is not the first report on sexual violence, and we know that we're coming into a conversation where women have been advocating for decades for change and have been making recommendations. And so we wanted to join that in solidarity and use the authority of our office to require a government response to the recommendations so that there can be public accountability.
And if I remember correctly, it was 43 recommendations that you made, right?
That's
that covered a whole range of different issues. It was really thorough. So thank you for the work. I know I said that already, but I think it's just such an important work, and we'll include a link to it so that if people do want to read it, they can. Turning to the others, and maybe we'll start with you, Silvia. what was your reaction to the report when it came out? And then we'll go to Alexa and then Tanya.
Ben, again, thank you. I really echo Pam's sentiments. It's an excellent report, and I just jotted just a few words that I thought it was thorough. You spoke to survivors, which is so integral to the work that we're doing, because survivors' voices need to be heard. And that was totally woven in through all the recommendations in the report. I felt it was very respectful of survivors and the folks who do this work. And I felt it was really solution focused. And I'm really hoping this is the last report we ever get on this and that the recommendations go through, because I think it's, as someone who's worked with survivors for many years, it's highlighting the problem, but also really solutions in terms of how we can fix the system. So again, I thought that the report is excellent. So again, thank you very much for doing that on behalf of the folks that we work with.
And Silvia, I think that's a really good point that you brought up, that it's solutions-based. It's not just shining a light on the problem. It's offering doable, concrete solutions. They're not pie in the sky type solutions to the issues. They're ones that the government can and should implement. Now I can't remember who I said was going to go next, but Alexa, maybe we'll turn to you.
Sure. Yeah. So being as involved in this report as I was, I sort of got to see it evolve and develop, and it was exciting to be part of that process. I'm thrilled with the result. Getting the survivors' voices in there to the extent that report does serve to drag out of the shadows a lot of the toxicity and the harm that was being levied against them. And so I do have a lot of hope going into the next sort of parliamentary session that it will be the catalyst for change that we need.
And last but certainly not least, go ahead, Tanya.
Hi. I mean, this report is very personal for me, and it was something I was living through when I connected with Ben's office. And I don't think we realize when we're going into the justice system, like, you might know about it, but it's not the same as when you go through it yourself. I mean, we think that reporting sexual assault is a serious offense, or sorry, that sexual assault is a serious offense, but it turns out that it's the reporting of it that is the serious offense, because everything is used against you for reporting, and you're treated like you're fabricating evidence or that you're making things up. And I think that this report is really helping to show that we're telling the truth when we're reporting. We're trying to protect other people. And I really appreciated the testimonies from the other people that are in the report, like how personal it was and how much it affects you, especially when your private records are subpoenaed the way mine were as well. So yeah, it's very powerful and very personal.
Well, maybe on that, we could talk about Section 278(1) of the Criminal Code, which is what we met with when I first met you. You not only have been, and I don't say this lightly, but you've been incredibly brave telling your story publicly. It's one thing to have to go through this, and it's another to have to relive it, to talk to an MP that you don't even know and share intimate details about what you've gone through. But I will say that, the work that you folks have done has really made a difference and shone a light on an issue that I don't think anybody was talking about if it hadn't been for you. So can you maybe talk a little bit about what the issue is with Section 278(1)?
Sure, I would be happy to share that. I found that it was like I was being threatened that my private records were going to be subpoenaed. So before I actually received the subpoena, I already knew that they were coming. And the defense had been threatening it for over 1.5 years before I actually received the subpoenas. And I filed my complaint with Ben before I received the subpoenas as well. So it is used for witness intimidation. It's used for character assassination. And the Section 278 is reviewed by, let me just slow this down a bit. So my Section 278 application is based on misleading information. It is there's full of false allegations against me that the defense has put in there without any evidence, and I don't get to defend myself against what they put in the report. And it ends up going to the trial judge. So when the subpoenas came in for 7 years of my counseling records, all of the records have to go in before stage 1. So even if it's not going to be given to the defense, it still gets given to the court. And I feel that that's an invasion of my privacy. And my counselor would have had to pay like hundreds of dollars an hour to vet, or like she was trying to defend my records going to court as well. So it's a huge strain on my therapist. It broke our therapeutic relationship because she's not trying to betray me, but the defense is using her to betray me. And I also had to cut off the counseling record with her, but also with the Sexual Misconduct Resource Center, because anything that I say to them was also caught under the subpoena. And I did have a Section 278 lawyer who even told me that I wasn't allowed to talk to Ben Roebuck because those records can be subpoenaed too. So if the justice system has been silencing victims, that was continuing to make us not be allowed to talk to anybody. And it takes years to go to trial. So if you can imagine not being allowed to talk to someone for years, that's a problem.
Yeah, and when you're talking about personal records, you're talking about if you were to go into a sexual assault center and speak to the counselors there, you're talking about, receiving therapy after the assault, which, you've been through an incredibly traumatic event, and you've survived it, but that doesn't mean that you don't need therapy. And I remember, first of all, being shocked that at that invasion of privacy, but also the way that the accused can use that information to re-traumatize the victim. So having access to personal records means that they know your deepest vulnerabilities and can in turn re-traumatize you because they have access to that kind of information, right?
That was my big fear, actually, because the accused had already used a letter that I'd written to my commanding officer in Borden, where it had said something about a situation that would cause me to feel unsafe. And so I believe he received that information probably with disclosure, and he followed through on doing the thing that I had written about. Mm-hmm. So, to me, that's evidence that he would be using my counseling records to terrorize me after it was over.
Ben, I wonder, can you maybe talk a little bit about what your recommendation was? But also, I know we're jumping ahead a little bit here, but also how that was in turn included or not included in the recent justice bill that the Justice Minister has tabled.
Thanks, Pam. Thanks for sharing, Tanya. Mm-hmm. Our conversation with Tanya was really part of the reason that we launched this investigation. When we started to hear that women in particular who had experienced sexual violence were being cut off from access to mental health support when they needed it most, and that was in the name of justice. It's just not right. And so we spoke extensively with survivors and crown attorneys, defense attorneys, to try and find a way forward on this, because the Supreme Court has ruled that there can be sometimes value in what are in those records. We heard about a lot of abuses of the process. We heard about one survivor who had a disturbing dream that she shared with her therapist about smiling during the sexual assault. The reason she shared it was because of the distress she experienced. In court, defense used that dream to suggest that she was consenting to the sexual assault. And just last week, I was speaking with a journalist who was covering a story of a survivor who talked about the decision of whether or not to report with her therapist, which is such a common conversation. And the defense attorney was trying to suggest that that was collusion, that the therapist was pressuring her to come forward and maybe even invent a story. And so that needs protection. What we recommended in the end, after careful consideration, was increasing the threshold. Right now, the way that screening regime works is based on the idea of probative value. So if the defense can say there's information in here that's highly likely to be valuable to the defense, then the judge might admit that information. And so we proposed raising that threshold to necessity, which is quite similar to a class privilege like attorney-client privilege. And that's actually what was put into Bill C-16. So it sets out in the new legislation that's going to come before Parliament that the only way that record could be accessed is if it is the only possible way to raise reasonable doubt within the defense. And they need to know in advance what they're asking for in that record and demonstrate to the judge before they receive it why it's the only possible way. So it's quite a high threshold, and it's an important change, an important protection.
That's great. Silvia, I wonder if, SAVIS and you personally have been supporting survivors of sexual violence for many, many years. What are you seeing, and how can this report help survivors through the criminal justice process?
So survivors come to us through various, like they might, a friend might tell them, they might find out about when calling, 211 or phoning our helpline, which is 24/7, 7 days a week. And I think survivors, they talk about the real hesitancy to report. One of the things that we saw that was really disturbing last year was the Hockey Canada trial, which really, I think, shut down a lot of survivors saying, what's the point if I'm, as Tanya was saying, considered a liar all the time? We all know the stats are dismal in terms of how many folks actually do report, and then how many of those reports actually have some type of charge or some type of sentence. So we try really to encourage, and we work with survivors from the first time. Our motto is no judgment. So we really make sure it's all confidential. If people want to tell us their story in terms of details, in terms of their names, in terms of the phone line, that's great. We also offer counseling services, and so people can go through that process. And some people through that process feel that they can do the step of trying to go to justice. We also do a lot of work with Halton Police, and trying to really work with them and look at their the case reviews that Robin Doolittle talked about when she wrote her book Unfounded, that a lot of cases are considered unfounded. So what's stopping from a woman from reporting to the next step? So really trying to ensure that the survivors, that their voices are heard. And I think the bottom line is that we believe their stories. We believe what they're saying. And I think that's the most important part, is validating the fact that what they have said, we believe it, we treasure it. We use a trauma-informed approach. So I think for us, it's like, no matter wherever you want that assistance to be, if you want to go down to the road in terms of trying to do some type of justice, that's great. If not, we are there in terms of supporting women, or sorry, not just women, all folks to ensure that they can sort of deal with the trauma that sexual assault has had on them.
So in terms of your work moving forward, how do you see the recommendations that in Ben's report helping women who do come forward?
Sure. So one thing that we're very cautious of is actually what we put down in our case notes. We're always very mindful that it's just a description, someone came to the session, because we have known for years that those notes can be used against survivors. So we're very cautious. So there's a lot of training involved, ensuring that notes are meticulous and that they're not going to be sort of turned against a survivor. So I think the report has so many elements in terms of how survivors could be supported. And if we just took a few of those recommendations, if we can hope for just a few of those, that would be wonderful in terms of surviving, again, feeling that that they're believed, and that there's a system in place that that does not judge them and does not use their assault against them, right? So I think that report, I would, as I was thinking, if this report can have as much media coverage as the Hockey Canada trial could, I think it would be so wonderful for the public to know that, for survivors to realize there is options, because the Hockey Canada trial was so public, and I think, as I said, I think a lot of survivors felt very disillusioned with that. But if this report could really sort of shine and really be publicized and really be taken on by the government and folks who make those decisions, I think survivors would really feel that they have been supported.
Yeah, and it highlights issues that have been going on for years. This isn't, as you said, Ben, that there's been many reports on this, and we haven't seen the amount of change that we do need to see. And you saw it, like you said, Silvia, during the Hockey Canada trial in London, the myths that even the judge used against the woman who came forward, who had to testify through, I think it was 7 different lawyers, or for 7 days. It was for 7 days, whereas some of the defendants didn't even testify. It's just, yeah, it's really troubling. And Alexa, what are your thoughts on as a survivor moving through the criminal justice system?
So as a survivor myself, and then working with a lot of survivors in my job, we just sort of see how unbalanced the system is, specifically related to sexual assault, because of course that presumption of innocence means there's also a presumption that the survivor is lying. So right off the bat, you're on the wrong foot. We also have a problem in that the Canadian Victims' Bill of Rights is not enforceable. And so the accused has many rights, as they should, but unfortunately the victims are left behind, sort of set off to the side, again, based on how the system is structured, and given very little information, very little support. And of course, there's a chronic underfunding of the justice system that's also playing in there.
So let's talk about the Jordan decision. And Ben, maybe I'll start with you to just explain what that is and what impact that has had on sexual assault trials, the ones that actually do get brought forward, because we know that that's a small percentage, and then within that small percentage, you've got cases that have been thrown out because of the Jordan decision. And I know that you've made a recommendation around that as well.
Yeah, the RV Jordan was a case before the Supreme Court in 2016, where the Supreme Court said that the accused has a constitutional right to timely justice, and that also is in the best interest of victims. And so they imposed a timeline of 18 months or 30 months, depending on the severity of the offense. And if the justice system hasn't completed its process within that time frame, then the case can be stayed or withdrawn or discontinued. And what we've seen is that an increasing number of sexual assault cases, because it's complex as it goes through the justice system, and there are protections like this regime around therapy records, those cases increasingly are the ones most likely to be stayed. And so statistics from 2022, 2023 found that sexual assault cases were 2.5 times more likely than other violent offenses to be stayed or withdrawn. And we know that that's just the tip of the iceberg. What we saw was that the RV Jordan decision affects decision-making through the entire criminal justice system, from the time when police decide to lay a charge to holding out on plea bargaining, or there's so many points, but cases are stayed or withdrawn preemptively as well, because they think that it will pass the Jordan timeframe. And so too many cases are being dropped.
And so what was your recommendation around that?
Thanks for that great follow-up, Pam. Yeah, we recommended that the safety interests of survivors, their charter interests to life, liberty, and security of the person, have to be considered. when there is an application for a stay. Right now, under the regime, there's no rights for victims of crime around those applications. So there's not even a right to be notified if the accused has applied for a stay. And we've heard of cases where victims weren't ever informed that it had happened and found out that it had been stayed. And in cases of gender-based violence, that puts survivors at risk, and it's dangerous, and we need to be thinking about that. And we mapped out alternatives to a stay. There's different ways to approach a remedy for trials that have gone on too long. And so we're really pleased again to see in Bill C-16 that's been introduced a whole package of remedies to R.V. Jordan, including needing to consider options other than a stay in cases of violence. And we think that's really positive.
Well, and I know in our area, Silvia, there's an old courthouse here, and the provincial jail is overcrowded, and judges don't want to sit in Halton Region. And so that leads to delays as well. So it's not just lawyers, doing things in the courts. It's actually getting the case before a judge. And with that finite timeline that was put in place by the Supreme Court, it really puts those that do come forward at a risk should that case be stayed. Especially, Ben, if you're saying that they're not notified about it, you could have your abuser or attacker out in the public and run into them at in the community. It's really scary. One of the recommendations that you made, and I'll go back to you to explain it, Ben, is around restorative justice. And I think there's a lot of misunderstanding about what restorative justice is. So maybe you could just tell us what you had in there around restorative justice.
Thanks, Pam. Restorative justice can look different, but at its core, it's about flipping the questions that we ask when crime has happened to who has been harmed, what do they need, and whose obligation is it to meet those needs. And so it's looking at what do survivors need moving forward. And we know that only 6% of survivors right now are reporting to the criminal justice system, but that doesn't mean that they don't have justice needs or want some kind of remedy. It's that we know that they're not reporting because of the harm that they've seen in the system. And so we heard from survivors who've participated in restorative justice that they found it, particularly survivors who also went through the court process and restorative justice, that restorative justice offered a process that was more consent-based, that respected them, that centered them in the process, that was highly attentive to their safety. It was voluntary. And they could directly address power imbalances and issues in the relationship with the person who had caused that harm. And so in Canada, restorative justice has been used for a long time, but not often in cases of sexual violence. Some provinces completely prohibit the use of restorative justice in those cases. And so we've heard from survivors that they want to have that choice. And then the bill C-16, I'm just going to keep coming back to it because we have a lot of wins right now, I think, in that legislation. It maps out a process for restorative justice in the criminal code. And it sets in all of those really important safety conditions, that it's freely, that it's voluntary, consensual, that you can freely withdraw at any time. And it sets out principles and protections that have to be in place. And so I think that's positive, and it's responsive to what we've been hearing from a number of survivors.
Since you brought it up a couple of times, the bill that was introduced just before Christmas, it did include a number of your recommendations. Was there anything that you were hoping to see in there that wasn't? And what was included in that? You've mentioned restorative justice, 278.1. Jordan, what were some of the things that were addressed in there, and was there anything that you were hoping that would be that wasn't?
Yeah, I think overall it's a really great news story. I think about 23, we've mapped out 23 of our 43 recommendations are partially or fully addressed in the legislation. We worked really hard to keep informing the Department of Justice and Women and Gender Equality about what we were hearing and talking through recommendations so that there could be action quickly on the report. So certainly there's RV Jordan addressing that is one of the most foundational pieces because that's disrupting so much for survivors. It addresses therapy records, introduces restorative justice. There's a good shift with sexual history protections being extended to all sexual offenses. So that includes sex trafficking, which right now doesn't have access to that protection automatically. And we heard really clearly that that was important. And there are some really significant changes to the Canadian Victims' Bill of Rights, including making the rights to information proactive. And that's huge, that we're saying in Canada that when somebody experiences violence, just like the person who's accused of causing that harm, they should be told what their rights are and provided that information. And so that's included in the bill. I think maybe two areas where I'd still love to see some action would be strengthening the enforceability of the Canadian Victims' Bill of Rights. And there's some parallel recommendations that aren't legislative, like investing in independent legal advice for survivors. That's really crucial. And in Canada, that funding envelope is coming to a close in March. That critically has to be renewed by government. And then the last area that I'm still hopeful to see a change is around preliminary hearings for children. Right now, since a change a number of years ago where preliminary hearings were removed for sexual offenses, except for offenses where the prison term could be longer than 14 years, because offenses against children are the most serious, then those are the ones that we're going to keep holding those preliminary hearings. And so children are more likely than adults to have to testify twice and to have to take in really problematic messages that can have life-altering consequences about suggesting blame to a child for sexual assault or sexual abuse. And so that really needs to be addressed. And I urgently think that still needs attention.
You know, on the funding, that was a recommendation that we made way back when at the Status of Women Committee, because we heard repeatedly that, you know, when people come forward, and it's usually women, they know the defense has a lawyer. They think the Crown is their representative, but the Crown is actually representing the Crown, and they're left without any kind of representation. And so, you know, having the funding available for people to have independent legal advice and support through the criminal. And I know organizations, Silvia, do you offer that through SAVIS?
We don't, but it's a real hindrance, especially if for folks who are, you know, finances are an issue. And for a lot of folks we work with, it is an issue. So, you know, there's legal aid, but again, it's really hard that those lawyers are far and few between, right?
Mm-hmm. Yeah. Alexa, what do you see? And Tanya?
Yeah, so same thing in my work, that the accessibility of legal support is nearly impossible, hugely problematic. And even if you can get a legal aid certificate, finding a legal aid lawyer is very, very difficult, and not all of them are willing to function in the capacity of a support lawyer during a criminal process. Most of them are involved in sort of family court type things. So yeah, it is a huge problem, and the fact that that program is scheduled to end in March is very, very scary.
Tanya, did you want to add to that?
Yeah, I wish I had I wish I had spoken to a lawyer before I talked to the police. There's too much information that I shared with the police that was irrelevant to the actual assault itself. And I think sometimes we overshare because we're trying to show that we're telling the truth. And because this was a military sexual assault, the military provides a defense lawyer. And I was saying that this should be provided for the victim as well. So now the Sexual Misconduct Resource Center does have legal representation to assist with victims in that case, but I just think it should be balanced. So we should each have a lawyer that can help us to share the information that is relevant to the case and not be sharing information that's not relevant to the case.
Mm-hmm. Well, you know, I read We Breed Lions over the holidays, which is Rick Wested's book. He's the one from TSN who broke the story about the sexual assault that happened in London. And I know one of the stats in there that was so depressing was that there's never been a conviction of a group sexual assault, which just shocked me. And the way he phrased it was, you know, and guess how many convictions there have been? 0. And you think, why would a woman even come forward, right? Why would she even come forward to go through that process when the prospect of conviction is just so slim? I asked Ben what he thought about the new justice bill. I'm curious, did anybody want to give their thoughts on what was in it or what wasn't?
I think Alexa and I would like to give some of our thoughts. We did some amendments, which we're grateful to Ben for including in his report. And I think like relying on judges to make good choices, if they were already doing that, we wouldn't be where we are. Like we wouldn't be saying that this needs to be in legislation in order to like prevent the judges from doing whatever their individual biases are. And the law is applied inconsistently. We also think that the private records, like my private records, are not going to help my offender defend himself against me. Like it makes no sense. So we think that there should be a complete prohibition on those record subpoenas. And we also think that it's the threat that counts. So really the value is in being able to intimidate the survivor by subpoenaing those records. So we would like to see stronger, like a complete prohibition on that. And we also would like to include the ban on subpoenaing personal journals and diaries. And what we wrote in our amendments is that the victim should have the right to provide things that are in their diaries or perhaps even in their counseling records that supports the assault, because my counseling records 100% supports my assault. And so do my records, my private journals. But the way it gets used in court is cherry picking, and like without the full context, which you don't get in court, everything is going to be twisted to use against you, which is wrong.
Alexa, what about you?
Yeah, so I saw lots of good stuff in that bill. It gave me a lot of hope, quite frankly, especially given that it mirrored a lot of what came out of the systemic review. But again, on the therapy records side, I wish we could go further. Just if you sort of big picture, like it's just so offensive, the thought of having your innermost thoughts and feelings handed over to your abuser, and hugely problematic that in practice what that ends up doing is cutting off support to survivors, mental health support, as they're navigating what is a hugely stressful process. So yeah, if I had my way, there'd be a complete prohibition.
Are you going to ask to testify, or will you submit a brief to the committee? I hope you will.
Absolutely. Yes,
Good.
I plan to. Mm-hmm.
Good. Sylvia, anything that, what are your thoughts on the bill?
Yeah, no, it was really quite encouraging to see how many recommendations actually had been put forth as part of the bill, because in my long history of working in gender-based violence, that's often not the case, right? So and I know with the survivors we work with, the RV Jordan is a real problem, because we've seen over and over again where defense just, number one, either the accuser shows up unrepresentative, and then that sort of just keeps delaying stuff. And survivors feel very frustrated that they've taken the courage to come forth, and now it's going to be basically abandoned because of the tactics that often defense does. So I'm really hoping that that's going to have encourage survivors that sort of issue hopefully will sort of be fixed, and that the tactics used will no longer be part of that process.
Well, something that came up a couple of times is the Victims' Bill of Rights. And I think I saw, Ben, today on Instagram that is having its 10th anniversary this year. Is that right? So
Yeah.
how do we make that enforceable? How do we get the government to make that enforceable, Ben?
What a beautiful question. Our office is about to release a 10-year progress report on the Canadian Victims' Bill of Rights, because it actually has more strength in law than it's given credit for. It's quasi-constitutional legislation already. So federally, like the Privacy Act or like the Human Rights Act, and we see it often being treated like a suggestion document. And so I think some of what we need to do is actually center and recognize the charter rights of survivors to equal protection and equal benefit of the law, and then recognize that that is law already. The biggest challenge with the bill is at the very bottom, after mapping out all of the rights in the legislation, it says that it doesn't in any way give standing to victims, it doesn't make them a party of the offense, or it doesn't allow them to sue for damages, so there's no right to pursue civil action, and there's no right to appeal. So if the rights weren't respected, the only remedy that's actually put into the bill itself are complaint mechanisms. And being responsible for a complaint mechanism, I know there's things that we can do, but there's things that we can't. And even federally, our office doesn't have the same legislative powers as the Ombud for people in federal prisons. And we're working often on different aspects of the same cases. And so, there's work to do. But one of the positive pieces is that part of the way that the CVBR is meant to kind of continue to develop is by bringing victims' rights into other legislation. And so we see Bill C-16 doing that in the criminal code. Particularly, I think one of my favorite changes is around testimonial aids. And it's fantastic. It assumes that survivors of violent offenses should have access to testimonial aids. If people appear in court and they don't have them, the judge is required to ask if they were given the choice to have them, which is awesome. And if for any reason it is contested, the judge only has to write a written decision if they're denying them, which is awesome too. So, they shouldn't deny them, but those are changes that take the CVBR, the Canadian Victims' Bill of Rights, and bring it into other legislation, and that's part of the way that it becomes enforceable.
Well, it's you mentioned a few of the challenges your office deals with. You also have a much smaller budget than the correctional investigators, so you're doing all this good work in a pretty lean machine there in your office.
Thanks, Pam. Can I just give a shout out to all the people across Canada who helped with this investigation? We pulled off like a public inquiry with no additional funding largely. And it was, sexual assault centers and survivors volunteering their time, and child and youth advocacy centers offering to organize consultation tables. And we had so much goodwill and so much solidarity across Canada. And it really, I think that's encouraging that we're working together and that, we're working for change.
Well, I'm really proud to know all of you and the work that you have done and continue to do. And as a Canadian, I am so proud, Ben, to have you representing us as the federal ombudsperson for victims of crime. I wish more people were paying attention to the work that you've done, and maybe all of us and anyone watching or listening can reach out to their MP and tell them, read the report and make sure that you support this new justice bill, because it may not do everything that's needed, but it's certainly a step in the right direction. So thank you all for being with us here today. Kevin, do you want to close us off?
Yes, that'd be great. Well, thank you, Pam, and thank you for all our panelists today. That was a very, in some ways, sobering discussion, but I think you also put a lot of solutions on the table. And that's why we have these discussions. That's what the Pearson Centre is for, ensuring that we get better public policy by having these kind of discussions. So thank you all for participating today and putting these leading us in this very important debate. And thank you, Pam, again for animating this discussion. Again, I'd like to close off by thanking our sustaining sponsors for the Pearson Centre, MAPCO, CBTU, NWMO, the Nuclear Waste Management Organization, TikTok Canada, the Cannabis Council of Canada, Bruce Power, Sandstone Group, Fasken, and our media sponsor, National News Watch, North Star, and Spark Advocacy. Thanks again for everybody who joined us today, and we'll see you at our next podcast. Thank you.